All right, our top focus continues to be the big order in the Gyanvapi case. Now remember, the local court in Varanasi has ruled that the Hindu side's plea seeking the right to worship in the premises of the temple is maintainable, which means that the court will continue to hear this matter, and the next hearing is scheduled to take place on September 22nd. Let's listen into the reaction coming in.
आज कोर्ट ने हमारे सारे आर्गुमेंट्स को मान लिया है, मुस्लिम पक्ष की एप्लीकेशन रिजेक्ट कर दी है, प्लेसेस ऑफ वर्शिप एक्ट की उनकी जो प्ली थी उसको खारिज कर दिया है, वक्फ एक्ट की प्ली को खारिज कर दिया है। कोर्ट ने कहा है कि सूट मेंटेनेबल है। अब इस मामले की अगली सुनवाई 22/9 को होगी और एविडेंस लीड की जाएगी।
All right, so that's the latest that we're picking up. Varanasi court upholding the maintainability of the Hindu side's petition. The petition, remember, had sought the permission to, in fact, pray at the temple premises within the mosque. And remember, this means that the local court has said that it will continue to hear the matter without taking any sides per se. And the next hearing is scheduled to take place on September 22nd. And on this note, in fact, I'm being joined by Mr. Shivam Gaur, who happens to be one of the petitioner's lawyer. Sir, a very, very good afternoon to you, and thank you for making time for Mirror Now. Now, I want to understand from you, keeping aside this whole politics over religion, Hindu versus Muslim, I want to understand here what exactly is the legal. All right, we're trying to reconnect with Mr. Shivam Gaur again, but remember, that's the latest that we're picking up on the Gyanvapi case, the local court ruling that, in fact, it has admitted the Hindu side's plea, stating that it will continue to hear the matter. And remember, the next hearing is scheduled to take place on September 22nd. So pertinent to note that not like the court has taken any particular side of the Hindu or the Muslim. The court has just said that we will continue to hear this matter further, which means that the court will be hearing the arguments of both the Hindu and the Masjid committee's side. And the latest that we're picking up is that all eyes are now set on September 22nd, when, remember, this matter will be taken up again by the court. But for now, remember, the lawyers representing the Hindu side have said that this is indeed a big victory for the plaintiffs from the Hindu side. That is the 5 women plaintiffs who had sought the permission to pray in the temple premises. All right, and now once again, let's go across to Mr. Shivam Gaur, the petitioner's lawyer. Sir, a very good afternoon to you, and once again, thank you so much for joining us on Mirror Now and making time for us. I want to understand from you the legal and the constitutional perspective of this entire ruling by the Varanasi court. Of course, the matter continues to be heard, but what exactly is the significance of this ruling today?
Look, when the application was filed under Order 7, Rule 11 by Defendant number 4 and the Inzamia Committee,
All right, we lost him again. We'll try to reconnect. But remember, that's the latest that we are picking up. All eyes are now set on September 22nd, when the court will be taking up this matter for hearing again. All eyes are now set on what lies ahead for the Hindu side. Also, what will be the road ahead for the Masjid committee? Remember, the court has admitted the Hindu side's plea, stating that the matter is maintainable and that the court will continue to hear it. And let's once again go back to Mr. Shivam Gaur, the petitioner's lawyer. Sir, please continue. You were sharing your insights on the legal and the constitutional perspective of this entire ruling. Please break down the significance for our understanding.
look, the legal way, in the legal view we sought against the judgment today delivered by District Court Varanasi. In the order, the court clear and confirmed the maintainability. The order was very comprehensive and precise, and also it is stated and let down the places of worship act, Waqf act, and any said to be the Kashi Vishwanath act do not bar the suit, as only the plea was raised by the Rakhi Singh on behalf of Rakhi Singh by me, that Order 7 Rule 11 has a very limited and confined parameter to be stated, and only the question of law to be settled and scored at that stage, and no question of fact to be challenged or considered, and no challenge to the plaintiff government can be considered, as it is clearly beyond the ambit of Order 7 Rule 11 and cannot be considered or held up by the Honorable Court at this stage, and the same has been agreed by the District Court Varanasi today.
But so from my understanding, it's being viewed as a massive win for the Hindu side. The Hindu side is like, okay, this is our victory. You know, we have won the battle. But essentially, if you just look at it, technically the court has just said that we will continue to hear both the sides. And the next hearing is now scheduled on September 22nd. What do you have to say on that?
You are absolutely considered or by showed by anyone. Hindrance being imposed on the court proceeding. The court proceedings were hampered and hindered by the Anjuman Inzamia committee by these delay tactics. That delay tactic, that hindrance is being removed. Nothing else is being delivered by the honorable court today, and only it is the maintainability which is decided by the court, nothing else. There is a long battle to be legal battle to be fight by us, and we will fight the same.
All right, so thank you so much for joining us with your views on this entire story. And in fact, on this note, let's also go back to my colleague Harish, who's joining us live from the national capital. Harish, you know, for somebody like you who is an expert in terms of covering the legal and the technical aspects, you know, of such stories, if you could just break down the significance of this ruling and the legal aspect behind this, because right now, you know, it's just being celebrated as a big win for the Hindu side, whereas the court has just said that, you know, this matter is maintainable and we will continue to hear both the sides. So why is it being termed as a big win for the Hindu side and a defeat for the Masjid committee? You know, if you could just throw more light on the legal aspect.
Yes, it's a very important question raised by you. Remember, even the Supreme Court, when the matter had come here, said that before you go into merits of this case, let the maintainability be decided first. That is, whether the petition filed by the 5 Hindu women petitioners seeking permission for daily prayers on the murals and idols engraved on the western wall of the Gyanvapi mosque is permissible or not. Remember, why? Because the Anjuman Intizamiya Masjid, that is the mosque masjid side, had questioned the petition, maintainability of the petition itself, saying that it's barred by the Places of Worship Act, which provides for a status quo on the religious structures as on 15th August 1947. But the Hindu side had vehemently argued that the Kashi Vishwanath Gyanvapi Mosque complex does not come under the Places of Worship Act, but Ancient Monuments and Archaeological Sites Act 1958. They also argue that we are not seeking permission to alter the structure of the temple, of the structure, or claiming ownership, but we are only asking for the right to pray, only the praying rights. And therefore, they also argued that even this Hindus have been praying on the western wall of the mosque for past 2 centuries, and it was stopped only after the demolition of the Babri Masjid. So therefore, that is one more reason why Places of Worship Act won't apply. And what is the consequence of today's order? Consequence is that now the first hurdle has been crossed. The suit has been declared maintainable. Now the court will go into the court commissioner's report, 2 bulky volumes in which the Hindu side say they have a strong footing because remember there is a dispute whether the waters found inside the Wazu Khana, is it a shibling or a fountain, as being claimed by the Muslim side. So this is the biggest consequence of it. Now, once the court has declared the petition maintainable, now they will be going to the merits of the case. They will be discussing the, in fact, the court commissioner's report.
Absolutely, Harish. Yeah, so all eyes are now set on September 22nd when the local court in Varanasi will be taking up this matter for hearing once again. Thank you, Harish, for joining us with all those big details.